Thank you so much. I appreciate it. Thanks for having me. Before we get started, I want to assure you that this is a very complicated topic. If you go online and try to research and Google these topics, you'll be surprised to see that there's not very much out there in terms of articles interpreting coordination of benefit clauses. And there's a reason for that. As we go into this, you'll see that most of the questions you have are really going to involve a very detailed deep dive into the state law and into the plans, and particularly their coordination of benefit provisions in order to answer those questions. It is a complicated exercise. Even when you have the plans, the coordination of benefit provisions are very, very complicated and rather lengthy. So I hope to do the best I can in presenting this topic. I'm sure there'll be questions that I will not be able to answer. Feel free to email the AAOMS if you have any additional questions that I did not answer, or you can email me directly. And I will do the best I can to get back to you on any question that's unanswered after this presentation. So let's dig in. So why is this important to your revenue cycle? Well, these issues, particularly for patients that have medical and dental coverage, are very frequently occur. Which plan is primary? And having a basic understanding of the rules that address the situation where there are multiple plans that may provide coverage for services, particularly surgery services that involve a dental component, is going to assist you in getting claims paid quicker, avoiding unnecessary expenditure of resources such as staff time, wasting time filing appeals that are not necessary, securing greater reimbursements when we actually bill the primary coverage as opposed to a secondary coverage, which could delay things quite some time, avoid risk of allegations of fraud and abuse where we double bill, which is a no-no, and also audits. I can tell you that this topic is confusing to me, and I'm a licensed attorney. I've been doing this quite some time. I also own a medical billing company, and when I get these type of issues, a lot of times I'm scratching my head. So you're not alone. So specialists like the oromaxillofacial surgeon regularly face these type of hurdles, particularly when you're doing a surgery that involves a medical component, such as maybe a jaw fracture, that also involves maybe extraction of teeth. It gets complicated. When does the medical plan apply primary, and when does the dental plan apply primary? But even in non-dental world, two insurance plans applying medical coverage, one for the employee and one for the dependent, let's say, or maybe the employee has two employers with coverage for both, or maybe has a primary and a secondary. It gets quite confusing. So again, understanding these issues, I think what's most important is that not only will you get quicker revenue and maximize your reimbursement, you'll stay compliant, avoid refunds, and increase patient satisfaction. Nothing is more frustrating to a patient that has two good health insurance plans, or maybe a good health insurance plan and a dental plan, and nothing gets covered, which could happen, as you know. So coordination of benefit, the practice of determining or coordinating the order of insurance benefits. What's primary, what's secondary, when a patient has multiple health insurance plans. Like I said, one could be health insurance, one could be dental. So that's the issue. Most states have laws in their insurance law that deals with coordination of benefits and order of benefit payment. Unfortunately, the plans also have coordination of benefit provisions in it. So that's what makes it very difficult. You really have to understand the law of your state, and then you have to, many times, you don't have access to the plans, but you need the plans in order to make a determination sometimes. So I'm going to give you some tips on how to avoid the situation that you actually need to review the plans. And we'll talk a little bit about that. But, you know, these two bullets are general rules. So generally a plan will only pay an amount that, when combined with the secondary insurance plan, does not exceed the full extent of the payment of the plan that would otherwise be paid absent the additional coverage. And, you know, quite frequently, you know, you have a $10,000 surgery, it gets allowed at $5,000, gets paid at $2,500. There's a $2,500 deductible, and my client, the surgeon, wants to know, well, why won't the secondary pick up the $5,000 of that wasn't allowed? And I can tell you that generally that doesn't happen. And for the primary insurance, they're only going to allow what the plan allows, and without regard to the secondary coverage. And I can tell you in a later slide, the secondary insurers are only going to allow what the secondary plan would ordinarily allow. So if it's a Medicare secondary plan, they're not going to allow the balance that's not covered generally. Does it happen? Yes, it happens all the time, but not, you know, rarely happens. Second bullet point, secondary insurers do not typically pick up the entire balance not paid by the primary insurer, as I just said. Secondary insurers are only billed generally the deductible or co-insurance that's listed on the primary insurer's EOB or for non-covered services. And I can tell you in my experience, when there's a non-covered primary EOB, secondary also denies, even though they probably shouldn't, but they do. So again, a detailed deep dive into the plans is sometimes required. And under both insurance and federal law, you're entitled to a copy of the plans. And I'll talk a little bit more about that later. So how does coordination of benefit circumstances arise when a patient is covered by more than one plan? Well, it happens in a variety of ways. I just list a couple here. A patient could have medical and dental benefits. It's very, very common. A patient could have two employers, right, and has coverage on both. A spouse could be covered as a dependent on one plan, but primary in a different plan that she or he is employed with. For children, they could be covered under one parent and as a dependent, and also on another parent, particularly if the parents are separated or divorced. Older children could be covered under a university policy and also a medical health plan, or a group or individual health plan. My children are college age, and the schools that they go to, they offer student health coverage, which is a supplement in addition to group medical coverage or individual plans that the parents may have. So COBRA coverage, someone could be covered under COBRA coverage and maybe another individual plan, or maybe an accident plan, or maybe covered under a no-fault or a medical pay policy. So there's a lot of ways in which this comes up. Every time it comes up, it's a difficult situation. So, I think if you take anything away from this presentation, understand that if you're confused by these issues, you're not alone, and it is very difficult to solve one of these issues as to which plan is primary, which one pays first, and which one is secondary, without understanding the statute, the insurance statute that covers coordination of benefits. So I would encourage you that for the states that you're in, pull the statute that applies to your state for coordination of benefits. I have a citation to all of the state laws in a later slide. Pull that, research it, make sure you understand the state law. And then when these issues come up, you're going to have to make sure if there's more than one plan, understand that not getting a pre-authorization and not asking the question of the carrier pre-service as to which coverage is primary and which is secondary, making sure that you have pre-authorizations on all services you're going to bill. And you should do that for both plans. If you don't do that, there's a good possibility that even though there's two covered plans, that the carriers will not pay the claim. It's very common for, let's say, Aetna to say the other plan is primary, and then Humana to say, no, Aetna's primary, and they're pointing fingers at each other. So this is going to delay your revenue, and if both plans do pay, it's going to result in a refund. So you have to be very, very careful and diligent, and I would recommend that you train your staff that does the pre-auths and the eligibility to always ask the question as to whether there's another coverage. Not just, and make sure that the patient advises which one is primary and which one is secondary, but don't take the patient's word for it. Get a pre-auth on both plans, unless you know for sure that it's a secondary. For example, it's primary is Aetna and there's a Medicare secondary. But if you're not sure, get a pre-authorization for both plans and ask the carrier during eligibility which one is primary. Tell them there is another plan. There's a Medicare plan, and try to get them to give you an authorization and advise whether their plan is primary or secondary. If both plans are saying they're primary, that's a good thing. But if both plans are saying they're secondary, you got to do a little bit more digging. So, as a general overview of coordination and benefits, unfortunately, almost every case is a case-by-case analysis, a deep dive, as I call it, almost every case. You can avoid sometimes these issues by doing a very detailed verification of benefits call. You want to get pre-authorizations on both plans if you're not sure which plan is primary and which is secondary. You want to ask those questions of the carrier. Is this plan primary? There's another, we have an Aetna plan and a Delta dental plan. Understand the services being billed, particularly when we go through a medical plan and a dental plan. You will have certain procedures covered under dental and other procedures not covered under dental but covered under medical. You need to understand and get a pre-auth for all of the services that you're going to bill. And if after the surgery you did additional services or the services you perform change, because sometimes that happens during a surgery, you have 24 hours to get the authorization revised. So I think that a lot of these issues can be avoided with a very educated verification of benefits person that does the proper pre-authorization call, that asks the questions about the other coverages. At the same time, that person should understand what the state law says about coordination of benefits. And I'm going to give you the site that you can look up your state law. Okay, so there are some universal rules that apply most of the time, and I say most of the time because they don't always apply all the time. But most of the time, a plan with no coordination of benefits provision generally pays first. Okay, now, you're not going to know that, right? So you're not going to know that until it is necessary to get copies of the plans. Now, let's talk a little bit about the plans and how to get copies and why that's important. Now, particularly if you're a non-par provider. I can tell you like I said earlier, that I own a billing company, and we cater, most 75% of our clients are out of network, non-par. So in those scenarios, we always 100% of the time request a copy of the plan document. We do it for a number of reasons, not just coordination of benefit. We also keep a database of plans, and I strongly recommend you do that. We keep the group number, the employer name, the effective date, and how the plan allows at a network. Does it allow at a Medicare rate, 110% of Medicare? Does it allow at a usual, reasonable, and customary rate? Does it allow some sort of internal fee schedule? So for purposes of the rate that's going to be allowed, it's very important to get the plan and keep track of the plans. It's also very important for purposes of marketing. You know, we share with our clients, you know, the plans that we get copies of, so that they know the good plans and the bad plans, and we also keep track of high payments and low payments. So that's something that our clients really appreciate. You know, tracking the plans. Know, if you're out of network, know the good plans. You may want to focus your marketing in areas where the good plans exist. Just food for thought. And for coordination of benefit. If it gets to a point where you either get a situation where both carriers are pointing fingers at each other as to who's primary, or an insurer allows a claim primary. I have a number of cases like this now. And then a year and a half later, you get a refund request for $50,000 or so. And, oh, oops, we paid this primary, but we were really secondary. Again, requires a deep dive. And in those scenarios, if you don't have the plan, you request it. You're entitled to it. So you would not take the word of an insurance carrier if they're seeking a refund based on coordination of benefits. You want to see both plans. And you'll see that as we go through the universal rules, if a plan contradicts state law, that coordination of benefit provision is nullified, and that plan is primary, even though the plan specifically says that the coverage is secondary over another plan that may be primary. So let's go through some of the universal rules, and let's try to make some sense of this complicated topic. So I've already spent a lot of time telling you that it's not as simple as I have an in-network plan, health plan and an out-of-network plan, and which one is primary and which one's secondary. Generally, it's going to be very difficult for me to answer that question in most scenarios without doing a deep dive. But there are some universal rules, so we're going to go into them right now. Now, a plan with no coordination of benefit provisions generally pays first over a plan that has a coordination of benefit provision. So that's an important rule to know. And that makes sense, by the way. Medicare, Medicaid, TRICARE is typically a secondary payer with some exceptions. Well, if you're Medicare and the patient is over 65 years old, 65 or older, then the Medicare generally is in most instances is primary. If a patient is indigent, they could be primary on Medicaid. If a patient is under a disability, they could be primary on the Medicaid. TRICARE is primary when a patient is active in the military, for example. But it's not uncommon to have Medicare and TRICARE as secondary over and above a commercial plan. So just keep that in mind. Third universal rule, medical and dental plans are typically secondary to accident insurance or medical payment plans. So keep that in mind. Medical and dental plans are also usually secondary to no fault or PIP type of plans, workers' comp plans, and the like. I cannot overemphasize the importance of your pre-authorization process. My law firm does a lot of appeals. My billing company does a lot of appeals. The appeals that I have a very difficult time winning are the appeals for no pre-authorization. And it's very difficult to win those because the plans have preconditions. And for some services, particularly if you're out of network, but even if you're in network, there's a precondition that the carrier needs to know in advance that you intend, you, the surgeon, or the medical provider, is going to perform a certain procedure. And they want the opportunity to pre-authorize or deny the pre-authorization. So when you're dealing with two plans, you may have to pre-authorize, get a pre-authorization for both plans. So before you call for a pre-authorization, it's critical to know the diagnosis codes and the codes that you're going to use, knowing that they could change during surgery. And it's not a bad idea as a last question to ask during the pre-authorization process, what happens if during the surgery, due to unintended circumstances, we did additional procedures? How do we get those procedures pre-authorized? And usually they'll tell you that you have to call within 24 hours, reference the pre-authorization number, and they generally approve those as part of the pre-authorization. So, but again, when you have multiple health plans that may apply, you need to do an analysis of coordination of benefit. And I would say if you're not absolutely sure that this plan is primary and this is secondary, you may have to do a pre-authorization of both plans. And you may have to ask the question, and it's good practice. There are two plans. One is Medicare, one is Cigna. Which one's primary, which one's secondary? Remember that those calls are all recorded by the carrier. In certain states that allow you to record those type of calls, you can record them as well. And push come to shove, you know, the recordings are very, very helpful when you're dealing with these type of issues on appeal. So keep in mind that coordination of benefit is something that should always be at forefront of your verification folks when there's more than one plan. Okay, so some of the things to consider: is pre-authorization or prior authorization required under only one of the plans affording coverage, or both plans? 2, ensuring compliance with the pre-authorization requirements of both plans is imperative. 3, how does the failure to secure a pre-authorization affect coverage in coordination of benefit situations? And I would say even 4, ask the coordination of benefit question. Is this plan primary over Medicare? Is this plan secondary? You know, the patient has another plan. You're better off fighting that issue pre-service than having a claim get paid and a year and a half later getting a refund that has to be appealed and then eventually gets offset over, or could create, you know, these type of issues can also create audits that expand to other claims. If a carrier believes that you're not paying attention to coordination of benefit issues or pre-auth issues, they could request 50 charts, and now you're in a coordination of benefit audit. And I've had a couple of those, and they're kind of ugly because now you have to evaluate plan provisions for not just one patient, but maybe 30 or 40. And it gets very, very messy. And if you're dealing with an attorney or a consultant, it gets expensive. So this is important to train your staff that when there's more than one coverage, it's imperative that they ask the right questions, and they may have to do pre-authorizations for more than one coverage. I know I've said this a couple times, but I can tell you from experience that failure to get a pre-authorization on a second coverage that turns out to be primary, it's very difficult to win that. We talked a little bit about the effect of laws. It's absolutely critical that someone in your organization needs to pull the state law dealing with coordination of benefit and order of benefit payment in your state. You need to read that. There's usually a model a model clause that the carriers can put in their plans and policies. You should read that as well and try to understand the rules. I'm going to go into the NAIC model rule a little bit, but that model rule does not have to be adopted in your state. Generally, many states have adopted it into their own law, but not all have. But the model rule for the NAIC can give you a very good understanding of the issues that are in your state law. But I think as an initial evaluation, someone in your organization needs to pull that law and summarize it. If you have to, get a law firm like myself or someone, if it's too complicated, to summarize it for you. But you need to understand those laws. Keep in mind that violation of those laws, your recourse is to go to the Department of Insurance and explain that the insurance carrier is violating the state coordination of benefit rules. And those state laws, the regulators should take those seriously. So let's talk about the NAIC coordination of benefit model regulation. Just like any state law regulation dealing with coordination of benefit, the purpose is to establish a uniform order of benefits as to multiple plans that apply to a single procedure. That's the purpose. It gets complicated, as we discussed. So the NAIC is no different than your state law. The state law is trying to develop a order of benefits. The plans try to do the same thing. They have coordination of benefit provisions, and it's clearly marked in the plan. You'll be able to easily find it. And those provisions in the policies or plans need to be checked against the state law to see if they contradict. If they contradict state law, the odds are that plan is going to be primary over and above other plans. So, first purpose makes sense. Establish uniform order of benefits as to multiple plans. Second purpose is to reduce double billing. That could be a big problem. If you're not sure and you just decide you're going to bill both plans as primary without basically telling the insurer that there's another plan and both pay as primary, you have kind of a problem on your hand. You may be happy initially that you got a primary payment twice, but that can be considered insurance fraud, intentionally deceiving the insurance company for the purpose of deriving additional revenue. That's the elements of insurance fraud. It has to be intentional deception. It can't be that your billing company or your office billed two insurers primary by mistake. It has to be intentionally done to deceive the insurance company. If the insurance company thinks that you're doing that, even on one case, you could be involved in a full-blown audit that I've dealt with in my practice. Actually, even in my billing company, we had one that came up on one single case, and the next thing you know, they want to look at 50 cases, and it gets expensive very quickly. Insurance fraud can lead to not just civil penalties, but also criminal penalties. It can lead to audits. I can tell you for a fact, I've handled a couple of those. It can lead to refund demands, sometimes even offsets on other unrelated claims, even though the carriers are not supposed to do that. It can happen. And drastic remedy is the insurance company can terminate provider agreements if you're in network. So, you have to be very careful of double billing two insurance companies as primary. Don't recommend you do that. The other purpose 3, is to provide greater efficiency in the process of claims when a person is covered by more than one plan, and also to get claims processed quickly, fairly, and at maximum reimbursement rate. So the purposes make sense. Okay, so here's the model regulation. And if you go to the model regulation, you'll see that there's an appendix that has a sample contract provision, a coordination of benefit contract provision. So I would pull the model regulation so you have it, the NAIC model regulation, and I would look at Appendix A, which has the model contract clause that can or cannot be adopted by an insurance carrier or a plan administrator as part of their coordination of benefit rules. Not a bad idea to get familiar with it, especially if you don't have the plans. You can see what the provisions look like, and most carriers have adopted at least most of the NAIC model contract provisions. There's also, if you go to the NAIC model rules, you will see a listing of state law. So there's a citation to state law for each of the states. So I strongly recommend that you take a look at that, and I think it could be very helpful to you. But again, this is a model rule. State law is the law that applies to your state. And you can find the state law, again, by going to this citation. If there's any questions about that, just pop me an email or the AAOMS email address, and we can help you with that. Okay, model rules. Let's dig in. So these are the rules where two or more plans apply, and this is order of coverage. Which benefit pays first if there's multiple plans? And these rules relate to the type of plan. So a primary plan pays as if a secondary plan does not exist. We already mentioned that rule, but the primary plan will pay as if there is no secondary plan. The secondary plan generally pays as if there's no primary plan. However, their benefit determination is only going to be based on the allowed amount of the primary plan, unfortunately. This second rule is interesting because even an attorney in my law firm thought that the rule was reversed. I was a little surprised as well. But so under the model rules, if a primary plan is a closed panel plan, closed panel plan is defined as a plan providing services through a panel of providers contracted with the plan, excluding coverage for other providers that are not contracted except for emergency services. So that's the kind of plan that's basically like a PPO in-network plan with no out-of-network coverage. So if you're dealing with a plan that's an in-network plan with no out-of-network coverage, for example, the closed panel plans, and a secondary plan is not a closed panel plan, which means there's coverage for providers that are not in a panel, like an out-of-network plan. The secondary plan that's out-of-network is primary, except the closed panel plan, the in-network plan, shall be primary for emergency services or authorized referrals. So that's interesting. If you're dealing with an in-network plan and an out-of-network plan, generally, the general rule is the out-of-network plan is primary over the in-network plan, except for emergency services and services where there's an authorized referral. Interesting. Rule number 3, plans that have no coordination of benefit provision is primary. We discussed this rule already, but I don't know how you would know that unless you request a plan. I did not mention, but a lot of times providers will ask me, or their billing departments, well, how do you request a plan? Well, I have a form that I'd be happy to share with you and with the AAOMS. It's called a Summary Plan Description Authorization Form. And it's just part of the patient package that the patient signed. And that form with the ID card and the driver's license gets sent to the employer, not to the plan administrator or the insurer, but to the employer. So the authorization form generally has the employer name, employer address, the employee name, which may be different than the patient, right? And then we take that form, send it with a cover letter over to the employer with a copy of the SPD authorization and with the ID card and driver's license. And I very frequently get the plans. And then I keep track. I have a database of plans. And I think it's, especially if you're at a network, it's really valuable stuff to do that. It can help you in so many ways. But it can certainly help you for coordination of benefit issues. I started doing this for a lot of reasons, but I don't trust the insurance carriers when they tell me, for example, that their plan is secondary over primary. I don't trust them when they tell me it's a Medicare plan. A lot of times when we do verification of benefits and the carrier is telling us that it's 110% of Medicare plan, when I pull the plan, I find out it's not necessarily true, that the plan is discretionary, which means, yeah, it could be 110%, but it also could be a negotiated rate. It could be a reasonable and customary rate. It could be full charges. And sometimes it says, the plan will say that the greater of 110% of Medicare and a reasonable and customary methodology applies. So, you know, I don't like to take the sole word of the insurance carrier, particularly when I have to file an appeal, be it an appeal on coordination of benefit issues, low payment at a network, or even a medical necessity denial. The plans include definitions of medical necessity, experimental, and investigational. Those are really important to have, you know, when you do an appeal for medical judgment. The plans also have important provisions on how to file an appeal, who to file an appeal with. Some of the plans even have the names and telephone numbers of advocacy companies you can contact in order to get claims processed, or a board or a committee at the employer for second level appeals. I also find it really important that when I request a plan, I usually get an email from an employer representative that I find very, very helpful for appeal purposes. A lot of times if my appeals are denied, and you know, a lot of times the denials, as you probably know from the insurance companies, are boilerplate, I can go directly to the employer and get the claim processed. For example, I had an issue just last week where the plan was a reasonable and customary plan, and it was allowed at 110% of Medicare. And I had the plan. Clearly was a reasonable and customary plan. Should not have been processed at 110% of Medicare. But there you have it. I had received the plan from a employee benefits professional at the employer. I emailed my appeal. I showed the page where the plan was UCR and the appeal denial as to saying where United Healthcare said it was 110% of Medicare for out-of-network. And I said, listen, United Healthcare has discretion, right? But they can't just make up the benefit. They have to follow the benefit. That's what federal law says. So I was able to get that case reversed and paid. So instead of getting $795, I was able to get like $12,500 on a negotiation with that eyesight. So getting the plans are really important. And again, I don't do it for in-network clients, but all of my out-of-network clients, it's something that I do. And I think it's I find it surprising that every presentation I do, no one really requests a plan. I'm kind of surprised by that. All right, sorry for digressing. Let's talk about some more of the model rules. So, plan that has coordination of benefit rules differing from state law is primary. That's why it's important to get the state law. Rule 5, if one of the two plans indicates that it's primary, that plan is primary. We'll talk about what happens if both plans are primary later on. In other words, if both plans have say that the coverage is primary, there's a rule for that. We talked about this. No fault and auto med pay plans are primary over medical, individual and group medical plans and dental plans. Group plans designed to be a supplement of a basic package of benefits, kind of like an add-on, may, but doesn't have to, provide that the supplemental coverage is excess over the other parts of the plan. like a major medical, superimposed over, let's say, a basic hospital or surgical benefit. So obviously, you need to take a look at the plan. Couldn't answer that question without looking at the plan. So be careful, but keep in mind that a lot of these supplement plans are written to be excess over above the main plan. Now, this is very confusing, right? And it depends on your state law, but there are general rules in NAIC model rules of coordination of benefits relating to dependents versus non-dependents. So what's a non-dependent? A non-dependent is the employee who has issued the plan, the member, the subscriber, the policyholder. What is a dependent? Dependent is someone that's covered under the plan that's not the employee, the member, the subscriber, or the policyholder. It's maybe a spouse of the primary policyholder, the primary subscriber. That spouse, he or she, is a dependent, and the primary policyholder is a non-dependent. So as a general rule on the NAIC model regulations on coordination of benefit, the plan that covers members as a non-dependent is primary. Now that makes sense, right? And the dependent is secondary, okay? Rule number 2 on dependents and non-dependents. Medicare is secondary for the dependent, but primary for the non-dependent. All right, now, again, this is the model rule. It may not apply to your state. Dependent coverage for children. There's a lot of rules on this. I just gave you some because I don't want to bore you with them. But, you know, there's the situation that arises where the dependent child is covered by more than one plan for parents that are married and living together and parents that are divorced. Now, generally, the parents that are divorced, a lot of times a court order during the divorce proceeding will order 1 or 2 parents to be the primary coverage for a child. That's generally what happens in a divorce proceeding. Not always, though. So here's the main rules for dependent children covered by more than one plan. Unless ordered by a court, and the court can change this, the judges have authority to change this, but unless ordered by a court, the general rule is the dependent child whose parents are married or not married but living together, the plan of the parent whose birthday falls on the earlier date in the calendar year is primary. Crazy, right? So unless ordered by a court, the dependent child whose parents are married or not married and living together, the plan of the parent whose birthday falls on the earlier date in the calendar year is primary. Under the NAIC rules, if the parents are divorced or separated and not living together, the parent who is required to provide health care by the court order is obviously primary. Unless that parent has no coverage, I've had situations where that parent was required to be primary, but the coverage lapsed. Then the other spouse's plan is primary. In other words, the courts want to make sure that the child has coverage. So that's the point there. If both parents are required by court order to provide coverage, then 1A above decides who is primary. 1A is the dependent versus, the 1A above is unless ordered by court order, the dependent child whose parents has the birthday falling on the earlier date in the calendar year is primary. Now, this is very complicated. If you ask me a question during the question and answer concerning dependents, non-dependents, and dependent children, I am going to punt that question. I'm not going to answer the question because it involves a deep dive, and I'm not going to be able to answer a question like that, generally. We have about 15 minutes left before the question and answer, and we're making good time. Okay, rules continued. And again, rule number 3 makes sense. Active employees are primary over retired or laid off employees whose plans are secondary. Well, that makes sense. COBRA employees are primary over non-COBRA employees. I think that makes sense too. COBRA is federally required. Those federal laws generally preempt state law. If the order of benefit is not decided by the previous rules we just discussed, 1 to 4, if both plans have identical coordination of benefit provisions, And we talked about what if both plans say that they're primary or both plans say that they're secondary? Well, then the plan in which the patient was enrolled longer is primary. Plan in which the patient was enrolled longer is primary. I hope your head is not spinning yet, but like I said, any questions that you have, I'll try to answer them at the end of this presentation. If not, email me. If I cannot answer the question tomorrow, I will do the best I can to try to research your issue and get back to you. Okay, and you can email your questions to the AAOMS email address that they provided in the beginning of the slide, or my email, which will be provided at the end of the slide. Okay, let's move on. Number 6, model rule regulation. Patients with more than one employer, the plan in which the patient was enrolled longer is primary. So that's the person that's working at Microsoft and is working also part-time at Home Depot or at a diner. Plan in which the patient was enrolled longer is primary. That's if rules 1 to 5 haven't decided the order of benefits. Now, I get a lot of angry surgical clients and medical billers that they don't understand why the secondary insurer does not pick up what's not covered by primary. They assume that if there's 2 coverages and they're doing a surgery, that their entire charge should be covered. And we know in revenue cycle world that that's not how it works, right? Even with really good plans, that's generally not how it works. So the secondary insurer, under the model rules, calculates benefits that would have been paid absent the other plan. Again, primary insurers do this too. They calculate the benefits under the plan. The plan rules. Under ERISA, which is the federal law governing employee-sponsored plans, the plan rules. So the insurers are not very generous, as you probably know, in the revenue cycle world. They're not going to voluntarily allow things that they shouldn't. So they're going to calculate the benefits based on the plan. So I'm going to tell you the way what model rules say. The secondary calculates benefits that would have been paid absent the other plan and, quote, apply that calculated amount to any allowable expense under its plan that is unpaid by the primary plan. Allowable expense. So under the model rule, they're gonna figure out what the benefit is, and they're only gonna look at the allowable expense of the primary insurer. That's why they don't pick up what's not allowed, generally. Now, have I had secondary insurers pick up an entire balance? Yes, I have. Why did I do that? I don't really know, and I'm not going to question it. If it happens for you, all the better. Great. So, the total amount paid by both plans may not exceed the allowable under the secondary plan. So if the secondary plan pays allows at a Medicare rate, at 100% of Medicare, the secondary plan is never going to allow more than the Medicare rate. Now, generally, in the revenue cycle world, you're billing the secondary, the coinsurance and deductible listed on the primary EOB and non-covered services. That's what you're billing. That's the secondary. They generally will allow, what's on the EOB is allowed amount. They'll allow a portion of that. And sometimes they allow non-covered services, and sometimes they don't. And you really need to review the plan, the secondary insurance plan, to determine whether or not denial of the non-covered services is appropriate or not. But under the model rules, the secondary insurer only has to allow, or only has to calculate the amount that it's going to allow based on the primary insurer's allowable expense. So under state law, under that model rule that I gave you the citation earlier, if you go to pages ST 120-3 to ST 120-7, it lists all the state laws there. You can find your state law. You should know that coordination of benefits sometimes is even more complicated when you're dealing with Medicare. And I have a case right now that I'm dealing with Medicare secondary payer rules and coordination of benefit. And there's a whole litany of literature on the CMS website concerning this. You know, if you're appealing Medicare, you know that there are very stringent time frames that you have to follow. So be very careful with Medicare so that you don't blow time frames, and look at the Medicare secondary payer rules. I am not going to cover them, but they're called Medicare secondary payer and coordination of benefit and recovery overview rules, found on the CMS website. You can Google it. Under the model rules, EOBs must contain, quote, a plan shall, in its explanation of benefits, provided to a covered person, include the following language. If you are covered by more than one health benefit plan, you should file all your claims with each plan. Yeah, but don't file them at the same time, because you're going to be in a double billing situation that could be create audits for you and insurance fraud issues. So, but yeah, that's what's supposed to be on the EOBs. What I find frustrating, because I do a lot of appeals, is that the EOBs don't contain the things that are supposed to be there under federal and state law. And the denials don't include the things that are supposed to be there. A lot of times I'll get a denial saying claim processed correctly. That violates state law, violates ERISA, it violates these model rules, probably violates the state law under coordination benefit and the prompt payment law, and it happens all the time, and it's really frustrating. I also get boilerplate appeal responses, and those type of things are frustrating, but again, if you're ordering plans and you get the names and contact information of employers, that's another appeal that you can do, filing an employer appeal. And I find that to be very successful, by the way. Just food for thought. I've been doing appeals for a long time, and I have a lot of experience doing this. And I think to be effective at appeals, you have to be creative. And, you know, you have to take the time. We're in a world of volume, to sit back, uninterrupted, close your door, and come up with a creative plan to get the claim paid. Sometimes the best strategy is not to appeal, but to rebill, recode and rebill. So medical versus dental coordination and benefit issues. I can tell you when this has come up, I have an issue. I have a claim that I just resolved with Anthem. It wasn't so much a coordination of benefit issue. It was more of a which plan covers which service, because the procedure was a surgery that involved a fractured jaw, and it also involved extraction of teeth and certain things that would be covered under a dental plan. And those generally services that are covered under a dental plan are generally excluded under a medical plan and vice versa. So that's why the pre-auth process is so important. If you know the procedures that are going to be performed, make sure for both plans you call with the diagnosis codes and get pre-authorizations for the services on both plans. Don't bill medical on services that you know are going to be denied. Don't bill dental on services you know are going to be denied. Bill medical and dental for the services that are pre-authorized that you've been told in advance are covered. Otherwise, you'll be in a situation, which I've had, where both carriers are pointing fingers at each other, right? Pointing fingers at each other, and nobody wants to pay anything. And now you're not getting any coverage. And now you need to order the plans. You need to look at state law. It's a nightmare. All right. One thing I want to talk to you about is financial agreements. These are so important. So by billing clients, we have financial agreements that cover a number of things. The patient needs to, in a financial agreement, they need to agree that they're gonna pay their ordinary co-insurance and deductible, clearly. They're going to pay for non-covered services. They're going to pay for coordination of benefit issues. For example, if they're providing a plan as primary when it really is secondary and vice versa. Make sure your financial agreements cover scenarios, including non-covered services, so that at the end of the day, if as a last resort, you can just bill the patient, even if it's a network. Bill the patient and let the patient sort it out. So make sure your financial agreements are strong. You should know that if you're out of network doing procedures at an in-network facility, that you also have disclosure responsibilities under the No Surprise Act. I had done a presentation for the AAOMS on No Surprise Act, which I think you can purchase, but keep in mind that that's a whole area that really, in my opinion, providers are not really paying attention to. And, you know, in 2023, there's going to be, I think, some enforcement actions on this. Not so much yet, but in 2023 for sure. And make sure that you understand those laws as well concerning the disclosures you need to post on your website, in your office, and disclosures that the patient need to sign. So in a coordination of benefits scenario, be it medical versus dental or any coordination of benefits scenario where there's more than one plan, these are the steps that I generally take, okay? So let's go through them. First and foremost, review your state law on coordination of benefits. You will find it in the NAIC model rules. I gave you the page numbers. So review those and review the order of benefit rules, which is the coordination of benefit rules. 2, hopefully you verified the benefits with each insurer. You have a commitment from the carrier as to which services they're primary for and which services they may not be primary for in the medical versus dental scenario, which diagnosis codes are covered, which are not, that you've attained pre-authorization in writing, preferably with a pre-authorization number, covering all of the services that you're going to perform for both plans. You're going to bill the claim with the pre-authorization number and only those services that you know are covered. If you include non-covered services on the claim form, the whole claim may be rejected. This is a ploy that the carriers use. They will only pay part of the claim. They should pay, part of the claim, but they end up denying the whole claim, hoping that you won't appeal it or send a corrected claim. You want to make sure you have these verification calls in writing. You have who you spoke to, the time you spoke, the number you spoke, get a reference number for the representative's first name, last initial, and a reference number for the call. These calls are all recorded by the carrier, and push come to shove, you can get a copy of the recording. Generally, if you file litigation or you file a complaint with the Department of Insurance under these type of coordination benefit issues, or any pre-auth issue. If there's a dispute on which plan is primary, you're going to have to order copies of the plan, of both plans. Again, having an SPD authorization form sent to the employer with the ID card and driver's license is what you need to do in order to get the plans. What I do is I send that. If within 20 days I don't get a response, I send a second request. 20 days later, a third request, and then I have people call. And I generally get 50% of the time I get the plan. And then what I do is I keep a database of the plans. Again, from a revenue cycle standpoint, particularly if you're at a network, it's critical to do that, in my opinion. Elicit patient cooperation. Well, if the patient signed the proper financial agreements and the patients are ultimately responsible, right, then I think you have a better shot at getting their cooperation because they're ultimately responsible for the full charge for non-covered services, right? A lot of times the patient could contact the employer directly and or a plan advocate under the plan. A lot of these plans, especially the big companies, have advocates and we can get the claims processed that way. You can file complaints with regulators, generally after you file appeals, exhausting internal appeal remedies. You can file appeals with employer sponsors, like I said. I do employer appeals all the time. If it's a fully insured plan, by that I mean an insurance policy with a certificate of insurance. That's an actual insurance policy. You can file an insurance department complaint with the Department of Insurance where the policy was issued. If it's a self-funded employer-sponsored plan governed by federal ERISA regulation, ERISA law, then you can file a complaint with the Department of Labor, Employee Benefits, Security Administration. That's generally the steps that I take in dealing with these coordination of benefit issues. Okay, so that's the end of the presentation. This is my email address. If anyone has questions, to email me. And I do have a couple questions that I'm going to basically discuss. The first question is, you have a primary medical plan that's at a network. So you have primary medical at a network. You have an in-network dental, which is secondary. So primary medical at a network, in-network dental. The primary medical, as is the case with many out-of-network insurers like Blue Cross, they send the EOB to the patient. So can you balance bill the patient the amount because you don't have the EOB? You know, can you balance bill the patient without violating your in-network dental agreement? If you're in-network for dental insurance, you're not supposed to balance bill the patient, right? So it creates kind of a quandary. Can you balance bill the patient? Well, it is a difficult question to answer without viewing the in-network agreement. However, I would not initially balance bill the patient. If the EOB went to the patient, even though you do not have the EOB and the check because it was sent to the patient, you can get the payment amount, the allowed amount, the deductible and co-insurance amount, even if on Blue Cross. Blue Cross is generally the biggest culprit of sending checks to patients, as you probably know. If you have website access on the portal, you can get the some limited information. And, you know, a lot of times it'll say check went to the member, or you call and they say it went to the member. But remember, the patient has access to the portal, and they can get the actual EOB that maybe the provider can't get. So if you have a good financial agreement with the patient, you can tell the patient, listen, the check went to you, the EOB went to you. You need to send us the check and the EOB. But I would, you know, certainly if the patient received money, then at that point, I would contact the patient, send the patient an email, a check to patient email, and but I wouldn't wait for that. If there's a co-insurance and deductible, and you're able to get that information from the carrier, bill the secondary. And if the patient doesn't turn over the check, yes, then I would balance bill the patient. So check went to the patient. You're going to immediately contact the patient, email the patient. You're going to try to get any money they received reimbursed to you. If the patient doesn't cooperate, you're going to eventually balance bill the patient for the full charge. But you're also going to get the deductible, the allowed amount, deductible, co-insurance. You will bill a secondary and get payment on the secondary. And then at that point, if when the check comes back from the patient, if you don't get the check, then yeah, you would balance bill the patient. Keep in mind, again, if the out-of-network service was performed at an in-network facility, then you would have to provide the notices and consents required under the Federal No Surprise Act as well. That's the first question. Let me take a second question. Okay, so in this scenario, the primary is the medical in-network carrier. So primary is the medical in-network carrier, and the dental insurance is secondary, also in-network. So you have an in-network primary medical and in-network dental. Remember, I told you that when you have that scenario, and you know you're going to do services that may be covered under medical and may be covered under dental, and then vice versa, denied on some services, denied on medical, and denied under the dental, you need to do a really good job on pre-authorization and eligibility. You got to make sure you get pre-auths all the services that are covered under medical and understand the ones that are not covered under medical, and vice versa for the dental. So in this scenario, neither plan coordinated and both paid as primary. That's the situation we talked about double billing. The provider collected more than the provider's fee schedule. Okay? Is there a rule or a law that dictates the refund process when receiving a secondary overpayment? Well, if the amount that was paid more than the fee schedule that you agreed to under the medical, you're going to have to refund one of the two carriers, right? You can't, when you're a network, you're agreeing to accept the fee schedule for that service. So if the medical reimbursed you at the fee schedule amount and you got more for the services that are on the medical in-network fee schedule, in other words, they're reimbursed you for, not for services that are covered under dental and not covered under medical, but these are services covered under medical. Remember, you contractually agreed not to accept more than the in-network rate for medical. So therefore, you cannot legally contractually accept more than that. So you'd have to refund the medical carrier or the dental carrier. You can't, by also billing the dental carrier and getting an additional payment more than what you agreed to on the medical, you're most likely violating your in-network agreement with the medical carrier. Same thing with the dental carrier. So if you agreed for a certain service to accept that particular fee as full payment, you can't bill the secondary carrier, the other carrier. Is there a rule or a law that dictates the refund process when you receive a secondary overpayment? Well, yeah. Keep in mind, for all overpayments, there's insurance law that deals with this. Insurance law generally applies to fully insured plans. Okay, those are plans that are actually insurance policies, not self-funded plans. So the law says in almost every state that the insurance carrier cannot request a refund, even if it's a legitimate refund. They cannot accept the refund if it's beyond a certain amount of time from the date of payment. So for example, in Georgia, it's 1 year from the date of payment. So if you get a refund from Georgia, a Georgia patient, for an insurance policy, healthcare policy that was issued in the state of Georgia, that's 1 day over the 1 year from date of payment. Even if it's a legitimate refund, the insurance carrier is not entitled to that refund. And that refund needs to be denied. And if they try to take that money back, you file an insurance department complaint. I think Texas, it's 180 days. It's kind of a short period. All right. So again, the state law for refunds and overpayments, also referred to as recoupments, deals with fully insured plans. So when you get a refund, you need to evaluate the timeliness of it. If it's not timely, you immediately reject it with an appeal and tell them if they try to offset this amount, you're going to file an insurance department complaint. What if it's and by the way, if a refund is nothing more than a retroactive denial. It doesn't matter if it's a coordination of benefit issue, refund related to coordination of benefit, or if it's a claim that they claim at a network that they should have allowed at a Medicare rate, not UCR, or if it's a claim that they realize it's not medically necessary retroactively. It's a denial. You're entitled to appeal that. You're entitled to request the plans. All of that stuff is governed under insurance law and especially under federal law, under ERISA, for self-funded plans. So when I get a refund, I never, ever, ever agree to pay a refund without appealing and requesting documentation and advising that they can't offset. The carriers cannot offset. So keep that in mind. The timeliness provision is important. Make sure you know the law on refunds. It's in the insurance law, usually under the prompt payment law for your state. So even on a coordination of benefit type of refund, they need to provide supporting documents. But coordination of benefit, it's most certainly copies of both plans so that you can evaluate and review the coordination of benefit provisions. You need to take those provisions, compare them to state law. Do they contradict with state law? If they do, that plan is primary, not secondary. Compare the plans to state law and compare them to the other plan. You don't get a copy of the plans, you never agree to a refund request on coordination of benefit. If the plan is, if the refund is offset, you file insurance department complaints. Keep in mind that under federal law, for self-funded employer-sponsored plans, the administrator, which is Aetna, United Healthcare, the plan administrator, they're supposed to provide specific reasons for the refund with supporting documents. So I request, a lot of things, including the plans. Make sure you request that. Keep in mind, though, that if in a scenario like we just discussed, you don't want to keep double payment, especially if you agreed to an in-network fee schedule amount. So you want to, if you, ultimately at the end of the day, it makes sense to voluntarily refund. But before you do that, you would call both plans and coordinate that amount. The question continues, which fee schedule applies? Well, that depends on which is considered primary and which is secondary, and you can only find that out by evaluating state law and evaluating both coordination of benefit provisions of both plans. But in the question, it indicates that the medical plan is primary, so I think it's safe to assume that you should use the medical plan fee schedule. All right, and that means you agreed not to accept more than the medical plan fee schedule. So if the dental plan also paid, you need to reimburse the dental plan. That would be my recommendation. Remember the NAIC rule, which states, quote, if order of benefits is not decided by the previous rules, if both plans have identical coordination of benefit provisions, then the plan in which the patient was enrolled longer is primary. Keep that in mind. It's not uncommon that both plans are primary or both plans are secondary. So the plan in which the patient was enrolled longer ends up being primary. What if neither plan accepts the overpayment? Is the patient entitled to refund? It's exceedingly unlikely that a plan will not accept an overpayment. These plans are greedy and they want their money back. So in these exceptionally rare circumstances, the patient may be entitled to a refund, but without properly calculating the same, one or both plans may take exception to issuance of a refund. Again, I think it's unlikely that a plan will not accept an overpayment refund, but keep that in mind. Next question. You have the primary insurer pays in full, and I submit a secondary claim to collect over the allowed amount. So the primary paid in full. So if you mean that your total charges were paid, then of course you cannot submit a secondary claim. You're not entitled to receive payment above your total charge. And that means insurance payment and patient payment combined cannot be more than your total charge. But if the primary insurer is in network and they allowed and paid the full fee schedule amount, which you agreed to and accepted as part of the agreement that you signed, then you cannot submit a secondary claim, obviously. We just discussed that. But if the primary insurer is in network and the scheduled fee is allowed, but only partially paid because part of it is a patient cost share responsibility, like a deductible, then of course, yes, you can submit a secondary claim for the part of the allowed amount that is patient cost share. If the primary insurer is out of network, you can submit a secondary claim for any patient cost share listed on the primary EOB as allowed but not paid. The secondary insurer under the NAIC model rules which may or may not apply to your state. Remember the rule, it says that the secondary insurer will calculate benefits that would have been paid absent the other plan and apply that calculated amount to any allowable expense under its plan that is unpaid by the primary plan. So the total amount paid by both plans may not exceed the allowable under the secondary plan. In other words, the secondary plan is generally not going to pay or any portions that are not allowed by the primary. I just want to quickly, we have about 15 minutes left, talk about what happens if you get a recoupment, a refund based on coordination of benefits. Well, remember the slide that I talked about. When I get a recoupment for I just got one recently where Aetna is telling me that that they're secondary over TRICARE. Well, I called the patient and found out that the patient is actually primary. TRICARE is actually primary because I'm sorry. TRICARE was primary because the patient is active duty. So in this scenario, Aetna is correct. They paid as primary when they should have paid as secondary. So that refund is appropriate. I told my client to refund Aetna and bill TRICARE. Once TRICARE pays, Aetna secondary will be paid. What's painful there is that Aetna paid a really nice payment. But, you know, there's nothing you can do about that. But if you have a scenario where I have another one where Cigna is saying that they paid primary and they should be secondary, and secondary is United Healthcare, you know, that's a scenario that's tough to determine without looking at both plans. Now, I had requested United Healthcare, Cigna, to give me a copy of their coordination of benefit provision, and I requested the same for United Healthcare. So what they do is they give me basically what the wording says. Don't accept that. You know, not that I don't trust an insurance carrier. I generally don't trust insurance carriers. So I told them that's great. If that's what it said, you're probably right. I need to see the entire plan. And the same goes for United Healthcare. You need to look at the plan, look at the coordination of benefit provisions for both plans, and then look at state law. Now, what do you do initially? It's going to take time to get the plan. You appeal. Remember, the refund is a retroactive denial. We paid primary, we should be secondary. It's like any other denial. So what I do is I immediately appeal, and in my appeal, I say first level appeal and objection to refund request. And in the appeal, I specifically said, you're telling my client that you paid as primary, you should be secondary. In order for me to evaluate this, I need to receive the entire plan so I can evaluate and review the coordination and benefit provision. And then I said, I also requested United Healthcare provide me the same plan so I can look at their provision and I can compare it to the state law on coordination of benefit and order of benefit payment. So please do not offset until I get the copy of the plans, and I can't make a determination as to whether or not what you're telling me is correct or not until I review the plans and compare them to state law. You need to send that appeal letter immediately, all right? And to make sure that they don't offset. Once they offset, you're never gonna win the appeal. So, you know, make sure that you appeal, and then, you know, usually what happens is they start sending dunning letters. Every dunning letter you get, file an appeal. Even if it's the same dunning letter that you got a month before. You don't want to give them an excuse to offset on an unrelated claim. That's called cross-plan offsetting, right? Don't give them the excuse. Just continue to appeal. If they send another dunning letter, your letter is called a continued appeal and objection to refund. And tell them simply, here's my initial letter. I didn't get a formal response. I only got a dunning letter. Copy of the dunning letter is attached. I cannot evaluate your request until I get a complete copy of the policy/plan document, so I can review the coordination of benefit issue and clause and compare it to the state law. And I've also requested the same from United Healthcare. And once I get both of those plans, I'll get back to you. Now, if it turns out to be right, I'll recommend that my client refund it. If it's a lot of money, maybe I'll try to work out a deal with that, you know, on a repayment plan, and they're usually pretty good about that. You have like 10 minutes left. I do want to mention the No Surprise Act once again. If you're an out-of-network provider doing services at an in-network facility, the No Surprise Act applies to you. And I'm only mentioning this because I think it's an area that's been overlooked by the, certainly not by AAOMS Association, because we did a whole presentation on this. But I just want to let you be aware that, that if a patient, if you're out of network doing a service at an in-network hospital, for example, the patient can waive the protections under the Act by signing a form, and it has to be the form that's prescribed by the regulators. It has to be their form. And in that scenario, you also have to post notices on your website and in your office. There are consents and notices, disclosures that have to be posted on the website and in the office. And the patient, in most scenarios, can waive the protections under the Act. But if they don't waive the protections under the Act, you can only bill the patient the in-network cost share. And then you should be aware that some providers the patient can't waive the protections under the Act for some providers, which are called ancillary providers. Those are the providers like an anesthesiologist, physician assistant, diagnostic companies. In those scenarios, those are the most common scenarios where a patient would get a surprise bill. The patient cannot waive the protections under the Act, and you cannot bill the patient for more than the in-network cost share. The other thing I wanted to mention that I think is important is that there is a mandatory 30-day settlement mediation under the Act, where the carrier is required to open a negotiation and to negotiate with you for 30 days from the date of the 10 days from the date of the actual adjudication, the EOB. They're required to negotiate. I've been able to get insurance carriers to open negotiations on out-of-network claims based on that provision. Again, I'm not going to go into the detail. There's a whole nother presentation on that. But please, please, please be aware that that law went into effect January 1st, 2022. And I believe there's going to be enforcement starting January 1st, 2023. So make sure that you're aware of it, and you can contact AAOMS, and they can give you more information on that, or I can certainly give you some information. We have about 6 minutes left. Is there any other questions? Emily, I'm going to turn it back over to you.
Yes, thank you, Mr. Force. And the other questions that we've received, I'll just start off with the first one is, what happens when both plans state they are primary?
Okay, so if both plans are primary, remember that they're still seeing the screen, right?
Yes, we can still see your slides.
Okay. Where is it? If both plans have identical coordination of benefit provisions, you see this NAIC rule? Again, this is a model rule. It may not apply to your state law, but generally most states abide by this. So if both plans have identical coordination of benefit provisions. In your question, both plans are primary. The plan in which the patient was enrolled longer is primary. That's the answer to the question. Again, does that mean you don't look at state law? No, you look at the state law because this is the model rule. Does that mean you don't try to get a copy of the plans? If you would get the plans if this does not resolve your issue. But again, that's the rule. That's the model rule. I can't comment on the state rule. Okay, Emily, any other questions?
Yes, our next question is, what about when the medical insurance carrier states the procedure doesn't require a prior authorization?
That's pretty tricky. I've had scenarios, as I'm sure the questionnaire, the person that asked the question has, in which that carriers have said no pre-auth is necessary and then denied for pre-auth. I think that it's very important to get that representation in writing, and if you can't get it in writing, when you do the verification, I have a verification form that my clients fill out, and in it, I make sure that they get the date of the call, the time of the call, the person they spoke to. You know, the carriers will only give the first name, last initial, the reference number for the call, and specifically say on the form that John L. told me that these, not that an authorization wasn't required, that these services that we're going to bill, CPT code, with this diagnosis is not requiring a pre-authorization. You get me something like that, I will win that for you. If I don't have something like that, it's going to be difficult to win. So this is really about the pre-authorization process. Again, when there's two insurance plans or two medical plans, or a medical and a dental plan, you need to try to get pre-auths for the specific services and diagnosis codes for both, and also ask the questions as to coordination of benefit. You need to the extent you can document that they told you that with the specific CPT codes and the specific diagnosis, that's what you need to do. With the reference number for the call, who you spoke to. Again, the time and the number you called is important because those calls are all recorded. And if it becomes a big issue, you can get a copy of the recording from the carrier. Emily, any other questions?
Yes. So the next question is, how do you handle a medical plan that you send a pre-auth to, then you get something back that says pre-auth is not required for these codes?
Again, in that scenario, it's very similar to the last scenario. If you're getting a pre-auth that says these particular CPT codes with this diagnosis do not require pre-auth, then you're in pretty good shape. Now, as you know, pre-auths are not a guarantee of coverage, right? So there's going to be a caveat on that letter that says that this is not a guarantee of coverage, and they can certainly deny it for other reasons like coordination of benefit or based on benefit max, or maybe not so much medical necessity because they're pre-authorizing it. But yeah, you want to get that documented, and if they won't provide you something in writing, you want to document it in a verification form. And if you can get me something like that, I have a really good shot of getting it reprocessed. By the way, you always, before you do an appeal, you always want to try to get it reprocessed. That I do pretty good appeals, and they're drafted by attorneys, and I find a smart phone call has the best shot of getting a claim reprocessed, especially when you're diligent, because the carriers want you off the phone. So if you ask for a supervisor and you become a nuisance, a lot of times you can get those claims reprocessed. We've got like another minute or two, Emily. Anything else?
Yes, our next question is, what if you don't know that the dental requires you to send to medical first? How do you get a prior authorization when you didn't know it needs to go to medical first until you get the dental EOB?
It's tough. That's a tough question to answer. Again, it comes down to having experienced, sophisticated pre-auth people and getting those calls all documented. So if you know the services you're going to perform, you need to do a pre-auth for both. And you need to ask them the coordination of benefit questions, because let's face it, at pre-auth, you're not going to have the plans. You can't verify what they're telling you. You may need to verify what they're telling you at some point during the appeal process, but you don't have that. So you want to ask them, these are the services I'm providing. Which ones are covered under this plan? Let them try to get which CPT codes with the diagnoses are covered under the plan. And then you can tell the next phase 2 of that would be, patient has a dental plan as well. Do I need to submit this claim to medical first or dental first? Try to get it documented. But as far as order of submission, generally you know, what we try to do is we try to bill the medical only for what's covered under medical, and try not to include anything that we know is not going to be covered. And then we try to bill the dental only the procedures that are going to be covered under dental, and what we know is not going to be covered. Now, if you're not sure, or after the verification call, you're really not sure, then you're not going to be able to do that. You're going to have to bill any codes that you're not sure as well. You know, that's a really, really tough question to answer, and you're not going to know the order of submission. And a lot of times you're dealing with unsophisticated carrier representatives, many of which are not even in the United States and don't understand state and federal law. So, you know, if you want to email me more details, I might be able to give you a better answer. I wish I could, but it's tough one to answer.
Great. Well, thank you so much, Mr. Force. This does conclude today's program. This webinar has been approved for 1.5 hours of continuing education credit. A certificate of continuing education will be available upon completion of a course evaluation and assessment. To claim your certificate of continuing education, please return to the program page. If your office does require additional CE certifications, please email a list of participants and the original registrant's name to ceonline@aaoms.org. On behalf of the American Association of Oral and Maxillofacial Surgeons, I would like to thank you for your participation in today's event. Thank you and have a great day.